Good morning and welcome to our Coffee Talk Health Industry Seminar Series. Today's topic is the anatomy of a contract, a risk management perspective. I'm Karima Kanani, a partner in our health industry group who leads our corporate commercial practice, and I'm delighted to be with you here today to talk through this topic of the anatomy of a contract. We have a lot of material to cover today, and I am going to do my best to leave some time for questions at the end of the session. I encourage you to submit your questions as we proceed through the presentation, and you can do so electronically through the chat box that's available. I'll do my best to answer all the questions throughout the session and as well during the Q&A at the end. But if I don't make it to your question, please rest assured that we will send a reply to you after. So let's get started. We have a lot of material to cover today in the hour that we have together. Our agenda: what is a contract? A review of key contract terms. I want to spend a little bit of time on the duty to act honestly in contracting, and then finish and round up with a discussion on contract risk management. So what is a contract? That seems like it might be a bit of a simple question, but it's important really to go back to basics on what actually at law is considered to be a contract or a binding agreement. So a contract is a legally recognized agreement between two or more persons or entities giving rise to obligations that may be enforced in the courts. So a key feature of what we're talking about today in contracting is considering whether that document that you're entering into is intended to be binding. I often have discussions with many of you around the documents that are used to implement a variety of alliance and collaboration initiatives that are occurring across the province, where there is intention among the group to have a document that will have accountability for all those that are participating, and that on which you would desire to enforce on those accountabilities, but that the forms of the documents that sometimes you're working with are the form of a memorandum of understanding or a letter of intent or intention that may not be binding. Those types of documents, although they take the appearance of a contract, are not binding unless they're stated themselves to be binding and that you intend to be able to enforce on the terms that are there. Sometimes that is entirely appropriate because you want to have documents where the parties are coming together to document an understanding or a desire to further explore a relationship, but you're not necessarily intending to have an enforceable agreement. However, where you are intending to have an enforceable agreement, you do want to ensure that you're using the appropriate form and approach to your contracting. So the key message from this slide is when you're approaching any document that is intended to memorialize the relationship of the parties working together, you want to ensure and ask yourself the question, do you intend the document to be binding? And is it in the correct form to do so? Contracts are used in all aspects of your organization's operations. They're used very broadly for a variety of different things. And I've put some examples on the slide here. So, for example, to purchase services and products, you would be entering into service contracts. If you're engaging, as I just mentioned, in collaborations or joint ventures with other parties, you would have contracts for that. Leasing space or land or licensing space within a building, engaging contractors or employees, and the list goes on. These are just a few examples. So each of these contracts in all of these different areas of the organization are going to have specific nuances and formats and approaches that are specific to their subject matter. So for example, an employment contract is going to have a certain flow and certain terms and approach to how it's written, as is a construction contract that will often follow some of the industry forms like the CCDC. So while contracts may be templated for certain uses based on these different areas, one thing you should always keep in mind is that they are situationally unique. And so templates are helpful in creating organizational efficiency and organizational standards. But you want to make sure you are always considering the facts of each situation to ensure, one, that you're using the right form of contract, and two, that you make the necessary adjustments to its substance. So given the wide array of contracts that exist across an organization, clearly in the short hour that we have together today, we can't cover all of the key terms, approaches, or forms that would exist in all these different types of contracting relationships. There are, however, certain key ingredients that are found generally across all forms of contract. And that's where I'd like to spend my time with you today. It's talking about what are some of these key contract terms that will show themselves through many of these different forms of agreement. And why are they there, and what are they intended to mean, and how do you use them from a risk management perspective? So the first is, who are the parties to the contract? Who are you contracting with, and can they legally contract with you? This might seem like a very simple question, in that you know the parties that you're at the table with who you're intending to contract with. However, it's quite common in our sector that you may be engaging with groups or organizations that are operating under a certain business name or affiliation name that they desire to enter into the contract under. However, in order for a contract to be binding on the parties, it must be entered into by a legal entity with the ability to contract, and an entity who at law you would actually be able to enforce the contract against. So you want to ensure that the party who you are signing with is a legal entity with or group with the ability to contract. And that's something that, if you're unsure, that you can reach out to us and can be very easily determined by running a quick corporate profile search to determine whether or not they have legal status. The recitals. I won't spend a lot of time talking about the recitals. What the recitals are those initial statements that are at the top of the contract, where they have language, very nice legal language of, whereas, ABC, now therefore, XYZ. And they exist at the top of a variety of different contracts. Why are they there? They're really intended to be background statements. However, the important thing that you should note about recitals is that they need to be factually correct. Some courts have held that the recitals of a contract are conclusive evidence of the facts that they are intended to state. So if you are going to have recitals in your agreements, which most of you will, and they are very helpful for setting the context of the document, it is important to ensure that the statements that you are making in the recitals are correct. Often what follows the recitals at the beginning of a contract, or can sometimes be contained in a schedule to the agreement, are a list of defined terms. The purpose and use of defined terms is, one, to create efficiency in drafting so that you have consistent use of terminology throughout the document without having to provide an extensive description of the word every time you use it, and so that you have a clarity and meeting of the minds on some of the terms and language that you are using within the contract. The definitions are an important place in order to achieve clarity on the terminology that you're using in the agreement and make for a much more user-friendly document. The terms of agreement. So this is where contracts will begin to differ, right? So depending on the nature of and purpose for which you are using the agreement, the terms of agreement will read differently. And at the core, they're just the promises and obligations that you are stating for each of the parties under the agreement. What you want to ensure is that you're providing those with sufficient detail that you are documenting what you have agreed to. Once the contract is signed, it forms the document of agreement between the parties. So if there is a principle or a term that you believe has been agreed by the parties, you want to ensure that it is documented in that manner in the contract. Often we use contracts where there are a lot of detail that needs to be appended or referred to for clarity purposes. So, for example, if you're purchasing technology, there may be specifications related to that technology, and those things could be placed in schedules to the agreement. If you're purchasing services, you might have a more detailed and lengthy service description that could be attached to the agreement. The key message that I would give you on the use of schedules is that if you're going to use a schedule, you still need to refer to it in the body of your document and indicate that the detail is then contained in the schedule. Consideration. The whole notion of consideration, which is a very legal term, is essentially that each party needs to be giving or getting something in the context of the contract for it to form a binding agreement. And so this is essentially going to be the value that you are giving to each other under the contract. And that should be clearly documented within its terms. Sometimes that's financial, and other times there's other forms of consideration that are provided. Term and termination. The term and termination provisions of a contract are critically important. And when you are entering into a contract is when you want to be thinking about how you would exit that contract should you need to. The term provision will state the duration of the contract and any options for renewal. What's important to consider is whether in having options for renewal, that renewal will be subject to any additional terms that need to be agreed by the parties. For example, if you would like to have the opportunity to reconsider whether the terms are working for you or to re-examine the financial relationship. In some situations, there are provisions that provide for automatic renewal. And where you have an automatic renewal of a contract, you need to be very prudent with the manner in which you are managing your contract. In general, I recommend to organizations to avoid provisions that allow for automatic renewal so that you do not inadvertently find yourself in a further extended contractual relationship for having not provided the requisite notice to exit. Exit mechanisms are important. They're important for your own flexibility in being able to exit the contract voluntarily, for example, on providing a certain amount of notice to the other party, and also exit mechanisms in the event that the party that you are contracting with is not living up to their end of the bargain. These are provisions that then deal with automatic termination of the contract or the option to terminate for circumstances of what's sometimes called cause or default. In those circumstances, for example, if they're in breach of the contract terms, if they've made representations to you that are untrue, if they've breached the law in some way, you would want to be able to take action to be able to address that and potentially to exit the relationship. Where you're dealing with provisions on termination, it is equally important to think about, well, if we needed to exit for whatever reason, how would we unwind this relationship? What are the matters that we need to think about that must be dealt with upon termination of our arrangement? They could include things like how are you going to deal with payments? For example, in certain service contracts, there may be prepayment or annual payment mechanisms where you may want to ensure that you can recoup certain funds. If there's been a contribution or use of assets in the context of the relationship, how do you deal with the ownership or transfer of those assets? And increasingly important across many of our contracts these days is the notion of information, both confidential business information as well as patient information, and how will those be treated after the contract and relationship is terminated. Representations, warranties, and covenants. These all sound like very legal terms, and they really show themselves in almost every form of contract. At the core of it, a representation is a statement of fact. It's something that you confirm as a statement of fact through the contract. So, for example, asking the other party to represent that they are in fact a corporation that has the legal ability to enter into the contract. That is an example of a representation. A warranty or a covenant are more forward-looking type obligations. Warranties are promises or assurances of actions that are going to be taken or facts that they have provided. So in service arrangements, you'll often have reference to certain types of warranties. Those essentially at the core are statements that are being made that are promises of what are going to be done. A covenant is something similar, and it is something that will be done or that won't be done as you go forward in your relationship. So a covenant could be, for example, that the organization is going to use qualified and competent staff in the performance of their duties under the service agreement. That would be a covenant on their part of a responsibility that they are going to undertake. Indemnities and insurance. This is a key part of every contract that you're engaging in with third parties and sets the key allocation of risk between the organizations that are involved. What is an indemnity? An indemnity is essentially an obligation that one party takes on to make the other party whole for third-party claims resulting from their actions, their negligence, their breach of contract, their statutory violations. If a party engages in those things and a claim results, what the indemnity says is that it tells the other party, if you suffer a claim because of these things that I have done, that I will make you whole and cover the cost of those claims through the indemnity. The indemnity will often contain hold harmless language, and you'll actually see those words, indemnify and hold harmless. And what hold harmless means is that when they are indemnifying you, that they're going to also take over the defense of any claim that you're suffering as a result of their actions or inactions. Indemnification is something that can look very different depending on the nature of the contract, and so you need to be mindful. There are circumstances where parties will seek to have a release from liability, and sometimes as blatantly as using the words release. In those circumstances, what they're saying to you is that they will not take responsibility for their acts and omissions in the performance of the agreement. And that is something for you to critically consider from a risk management perspective when you're evaluating and negotiating entering into that arrangement. Other parties will provide an indemnity that looks like it is providing you with fulsome coverage, but they will then couple it with a limitation, often financial limitation, as to the scope of what they will cover under the indemnity. So for example, I indemnify you for my breach of contract. However, I'll only indemnify you to the amount that you've paid me in the last year, which leaves the organization that is seeking the indemnity with residual risk. That means that if a liability arises because of the conduct of the third party, they are only going to cover their responsibilities up to X dollars, and then you will bear the cost and expense of any of the residual risk. Again, a very important consideration in negotiations of contracts. This often materializes and shows itself in technology agreements, for example. One needs to consider carefully if you're willing to accept a limit, and if you do accept a limit, what that limit should appropriately be. Now, indemnity will often sit in the contract right next to insurance. They're like two peas in a pod. And why do you need to have insurance clauses? Well, indemnity protection is only as good as your comfort in knowing that they have access to the funds to actually perform and fulfill their indemnity obligation. And that is why you seek from them assurance that they have the requisite insurance in place. What is often negotiated is the terms of that insurance. What type of insurance are they holding? And what are the coverage limits and amounts that are contained in that insurance? Is it on an occurrence basis? Is it on an aggregate basis? And those are all questions that you should be asking yourself from the perspective of ensuring that does the insurance that they hold going to be sufficient to cover their accountability under the agreement to you. Confidentiality and privacy. Confidentiality and privacy are very important to every agreement, and they will often cover the confidentiality of each other's business information, so information that you are potentially sharing or that each party may be exposed to about the other's operations or business or financial planning. It also addresses confidentiality and privacy elements of dealing with patient information. Even where an organization isn't going to have direct involvement with patient or client information, they may be within your premises and engaging in certain projects or initiatives where they may be exposed potentially to patient or client information. And so you want to ensure, even where their mandate doesn't directly involve engagement with such information, that your confidentiality and privacy provisions in your contract provide requisite protections around their treatment of any patient information to which they may be potentially exposed. Generally, when it comes to confidentiality and privacy, we also recommend very clear terms around the obligation of parties to comply with their regulatory requirements. So these are requirements under confidentiality and privacy law, whether that be the Freedom of Information and Protection of Privacy Act, whether that's PHIPA, the Personal Health Information Protection Act, that they are in compliance with their legal requirements for confidentiality and privacy of information. Dispute resolution. Not all contracts will contain dispute resolution provisions. It's really something that is optional. The benefit of having a dispute resolution process is that it provides a mechanism and process through which to deal with disagreements between the parties on the contract terms without or before going to court. So often a dispute resolution provision will contain things such as having discussion between very senior members of the organization, perhaps the CEOs of both organizations, proceeding to mediation, and to try to come to a reasonable agreement on terms on the disagreement with the assistance of a third-party mediator or facilitator. And on the far end, it can involve arbitration. And the use of arbitration is a means through which there can be a binding decision, but does not require you to proceed through a court process. Whether you choose to have a dispute resolution process and the stages of dispute resolution that you feel are most appropriate to you will differ depending on the nature of the contract and even the nature of the parties involved. So this is something where you can craft a process that's going to work well for you. Where you do use a dispute resolution process, my tip to you is to ensure that that process includes how you will come to agreement as parties on who will be the mediator or who will be the arbitrator and what means are going to be used to determine that. By the time that you're in a situation of being in a dispute is not the time where you then want to be having the discussion about who's in fact going to assist you in the resolution of that dispute. General provisions. These are the provisions that are contained often at the back of the contract. Sometimes they're talked about as the legal boilerplate provisions, and my key message to you is it's not just boilerplate. Some of these clauses may only be a couple of lines long, but they are very powerful and have critical importance to your contract. So it's important that you understand and don't gloss over the general provisions that are at the back of a contract because they can have significant implications. And so without going through all of these in detail, I did want to at least run through them with you quickly so you have a general sense of what are the types of provisions that are being contained in this this list of boilerplate provisions often attached at the back of a contract. Assignment clauses often sit there. An assignment clause is one that will say that you cannot assign, and essentially assigning is legally giving or passing that contract on to another party, that you can or cannot assign that contract without the consent of the other party. There may be circumstances where you don't want to have a consent mechanism, or where that consent mechanism should apply only to one party but not the other. But you want to be mindful of the assignment provisions to ensure that you're turning your mind to whether or not the party you are contracting with should have that ability. Where you are silent, they will have the ability. Amendment provisions. You don't need to have a clause about amendment. If you don't have anything in your agreement on amendment, you're going to amend on the mutual agreement of the parties. And in fact, that's often what is done. But in some circumstances, amendment clauses are included. For example, if you're entering into a multi-party arrangement. I've worked with many of you on agreements where there may be 5, 6 or more of you involved in a collaboration initiative or arrangement, and where we need to consider carefully what will be the protocol for amendment and whether that will mean that everyone needs to agree to a change or whether there is a certain percentage of the parties that are involved that need to agree to a change, so as to ensure that the rest of the group isn't paralyzed in making movement on a contract because of one party that remains outstanding. Force majeure. Force majeure doesn't exist in all contracts, but you'll often see it. It essentially is what happens if there are events that occur that are beyond the control of a party. The acts of God type of clause, and often in the health system, we will include provisions unique in a force majeure clause that deal specifically with situations like health pandemics and epidemics. And so in those circumstances, you may want to have a mechanism to excuse performance for a certain portion of time until that event of force majeure can otherwise be addressed. Governing law. Governing law is very important where you're engaging with parties who are in a different jurisdiction than you. Certainly as we begin to move forward and engage across our sector in more innovative activity and the procurement of goods or services from companies that are coming into the Canadian space from around the globe, the terms on governing law become critically important. What you want for governing law is for the law that applies to the contract and its interpretation to be the law of your own jurisdiction. So we want the governing law clause to say that the governing law will be Ontario and that you will return to the jurisdiction of Ontario and the courts of Ontario for any matters related to the contract. Often, if you're dealing with a party from a different jurisdiction, they will want the governing law and attornment to be from their jurisdiction, and this can sometimes be an area of quite heated negotiation. Independent contractor. Where you are entering into arrangements where you need to clearly document that it is an independent contractor arrangement. There are often provisions contained in the general clauses that will set out that specifically and explicitly that parties are entering into the agreement as independent contractors. It will often go on to say that you are each responsible for your own employees and for your compliance with law in that regard, as well as that you do not have the authority to be able to bind or take action on the part of the other party unless it's explicitly provided in the agreement. Counterparts. We live in a technological world where we are not all, especially in our sector across the province, going to be able to meet to sign contracts in paper on the same page. And that certainly is not required at law. It is perfectly acceptable and permissible to sign agreements in counterpart. And in order to do so, you need to provide in the agreement the ability to sign in counterpart. And what that essentially means is that each party can sign the agreement and then exchange their signature pages, and that you do not need to meet in person to sign the same piece of paper or to circulate that same agreement amongst all involved so that everyone signs the same piece of paper. You can sign separately, and the signature pages are simply collated. Entire agreement. The entire agreement clause is also important, especially where you have been engaged in extensive discussions with the other parties at the table, or where there have been other documents that you may have signed as stepping stones towards the contract that you're then working on. What the entire agreement clause says is that the four corners of the contract are the entire agreement between the parties on that subject matter. They then precede any other discussions that you've had or understandings or other documents that you may have entered prior. And so if there are other documents that are involved in your relationship, you want to ensure that where they are related to the contract that you are entering, that you reflect those in the entire agreement clause so that all parties are clear on what the suite of agreements are that form the four corners of the contractual rights and obligations of your relationship. No waiver. The no waiver clause often reads like that you will not waive your rights or obligations in the contract just because in a specific instance you choose not to act on them. So just because an organization has breached a provision, the fact that you didn't act on it does not preclude your ability to act on it in the future and in relation to other breaches that they may engage in. Often a no waiver clause will also say that if you're in fact waiving something that is an obligation, that should be explicitly done in writing between the parties so that there is no confusion as to that waiver. Severability. Severability is the clause that indicates that if for whatever reason there is a part of the contract that is found to be invalid or unenforceable, that it can be severed from the rest of the agreement and the rest of the agreement can continue. You should consider whether you would want that to happen. There are sometimes circumstances where in fact you don't want to have the principle of severability, and that if there were any term of the contract that were to be found unenforceable, that you would want to call into question the full contract. So the key message, and I haven't put, I tried to cover as many of the general provisions as I could in the context of today's discussion, but they're not all here. The main message is just that although these clauses are only 1 or 2 lines each sometimes at the back of the contract, they're very powerful, they're not just boilerplate, and you should pay attention to what they say. The end of any contract, then, is the signatures. And you want to ensure that after having gone through this extensive process of entering into comprehensive and well-written agreements, that they're in fact binding and enforceable upon the parties once they've signed it. And to do that, you need to ensure that the parties who are signing the agreement, the individuals who are putting their signature to paper, are in fact the authorized signing officers of those parties who have the ability to enter into that contract and have the ability to bind the organization. And this goes not only for your due diligence in the parties that you're contracting with, but also for your internal procedures as well. Most, if not all of you, will have signing authority policies. And those policies will set out in detail for different types of contracts or different value of contracts, who in fact are the authorized signing officers who have the ability to bind the organization. And you should be mindful of that as you enter into your contractual relationships. If you have any question in that respect, you should consult your bylaws, consult your policies, and ensure that you have those items in place within an organization and that you have the organization socialized as to what those rules are. And I emphasize that because it's not uncommon that I get calls from some of you saying that, a manager of a department signed an agreement, and it's now come to your attention at some point later when there's an issue with the agreement, only to discover that they signed it and that it did not proceed up through the organization to the appropriate signing officers. And so you want to ensure that you have appropriate mechanisms and measures in place to ensure that all are aware of the signing process and who are the authorized signing officers. So that takes us through all of the key provisions that will often show themselves in a contract in a variety of different forms of contract that you may use in your organization. I'd like to switch gears then with the little time that we have, last 20 minutes that we have left together here, to be able to talk a little bit about the duty to act honestly, because this is something that has been coming up in my discussions with a number of you as of late. The Supreme Court of Canada, as you are likely aware, passed a decision in what is called the Bazin case. And that case established a duty to act honestly. It set out an obligation for parties that are contracting to perform their duties in contracting in good faith. And the term good faith was defined by the court as being honest and reasonable conduct. This standard of the duty to act honestly in contracting applies to charities and nonprofit organizations like all of you, regardless of the type of contract that you're entering into. And what does it mean, really? Well, it means that you want to ensure that you're being mindful of the way that you're conducting yourself in the manner in which you're implementing the agreement. It does not mean that you have an obligation to disclose information to the other party or to have terms that would be the advanced terms that would be in the other party's interest. It doesn't mean that at all, and it's quite distinct from your fiduciary duty in that regard to be able to advance your own interests in the contract. There's nothing wrong with advancing your own interests. But the good faith performance means that you won't actively mislead or deceive the other party in respect of specific contract terms. In fact, we often consider this duty to act honestly when you're in those situations where you have a problem under the contract. And in those situations, discussions that I've had with some of you have focused more around, well, we have a problem with this party under the agreement. We would like to address or enforce on that obligation or to terminate or exit the agreement. And what are the steps or procedures that you will engage in to ensure that should you be called upon on this issue, that you could demonstrate that you acted in accordance with this duty to act honestly and in good faith in the performance of the contract. And you want to be especially mindful of that where you're entering into a zone where there's potential for contract dispute because of an obligation you may choose to enforce or because of actions that you may take to terminate a relationship. I'd now like to round out our discussion by having a few minutes together about contract risk management. A lot of what we've talked about today is all risk management. Understanding these provisions and how they work enables you to have the power to be able to risk mitigate and manage through the terms of your agreements. The contract is a very effective risk management tool. It's important to remember that with contracts, they are going to govern your legal and operational relationship that you are entering on a go-forward basis. And so where you engage in an enterprise risk assessment and you identify certain pockets or areas of risk that need to be addressed or that would be prudent to address as you move forward with the relationship, the contract becomes your forum in which to do so through a number of the provisions that we've talked about today. There is great benefit to organization in standardizing your contracts and contract procedures internally. It increases efficiency and it reduces risk because you can ensure that when you're establishing a standard for your contract, that it is appropriately and thoroughly vetted as to its terms and conditions, which then sets a standard for risk protection for the organization in using those contract terms going forward. But as I cautioned you earlier, when developing templates or standardizing contracts, while the intention may be to create efficiency and reduce risk, if you do not have appropriate procedures in place to vet whether you're using the appropriate template and to make situational adjustments to the terms of the template format of the agreement, you could end up in a situation where you've in fact exposed yourself to more risk by using the wrong form of contract than if you had just started with a new contract from scratch. So it's a tool for contract risk management, but it requires you to be proactive and affirmative in the way that you're engaging in the use of these documents. The development of contracts and the entering into relationships is often through a competitive procurement process. And in the short time that we had together today, I've focused very much on the anatomy of the contract itself, and I haven't really spent time on the procurement process that leads up to it. We could spend just an entire session talking about BPS procurement. But what I did want to flag for you is that where a procurement process is required, whether it be through BPS, through your funding agreements, or even your internal policies, that the process for releasing requests for proposal documents and other documents will require that you attach the form of contract or key contract terms. That's in fact a requirement of BPS procurement processes. Doing so is actually to your benefit. It enables you to control the form of contract that you're going to use and to increase your bargaining strength on its terms by setting out what your expectations are through the procurement process and enabling the other party to identify specifically what their areas of negotiation will be. When you're engaged in this type of competitive procurement, it is critically important that you give close attention to the contracting terms early in the process. Once you attach your key terms or a form of contract and they are released with your procurement documents, it can be very difficult, if not in some circumstances impossible, to go back and make changes to what you've put out within that process. So it is important to ensure that you attach the right form of contract with the right terms at the early stage of issuing the procurement documents, so that you don't put yourself in a situation where you've created risk for yourself through the procurement process instead of using it as a bargaining and risk management tool. Equally important as entering into the right contracts in the right format at the right time is ensuring, once they are entered, that you have appropriately established internal contract management practices and processes to oversee the implementation and enforcement of those contracts. Many of you, for this purpose, have contract management offices or teams that engage in this exercise. For those of you who are smaller organizations and who may not have dedicated teams to do this, it's important that you have internal policies or procedures that are going to address how this will be done and who it will be done by. It is important, once you've entered into a contract, that you then go through it and bookmark your key obligations that you must fulfill and key dates. So for example, when is the contract going to expire? Is there a date by which you need to provide notice if you intend to renew, or a date by which you must provide notice if you intend to exit? Any key dates or milestones that are contained in the contract should be identified and bookmarked for effective implementation. And throughout, no matter which form of contract you're engaging in, you want to ensure that you are affirmatively using it to your best risk management potential. And in order to do that, it can't just be signed and then filed away. You need to continue to review those terms, to document what needs to be done or what has not been done, and to enforce on the provisions of the agreement. So we've had quite a fulsome discussion today about the anatomy of the contract. We talked also about the duty of honesty in performing those obligations, and then how we use everything we've talked about today and the contracting process more generally as an effective risk management tool. So what are the key messages then that I'd like you to take away from our discussion? The first is, when you are entering into any arrangement with another party, ask yourself the question of whether or not you intend to have a binding commitment, and ensure that you're using an appropriate document for that purpose. Secondly, when you're entering into an agreement with a third party, ensure that the parties that you are contracting with have the legal ability to contract with you, so that you ensure that the contract or agreement that you are entering will in fact be enforceable on those parties in the future should you need to act on it. Understand the implications of contract terms. Some of that will be the detailed terms of the agreement that are going to differ by the nature of contract you enter into, but some of those, as we've talked about, are many standard terms that are contained in contracts that are important not to gloss over, because it's within those terms that you have some of your strongest risk protection. Use your contract as a risk management tool. Contracts are a matter of negotiation, and you should be engaging in enterprise risk processes more generally as it relates to entering into any arrangement. Where you identify risks, the contract is your forum to be able to mitigate and manage those risks, and to ensure that you have the appropriate allocation of risk, accountability, and liability among those parties involved. And last, but certainly not least, to increase your bargaining strength and your organizational efficiency, it's important and often beneficial to advance your own form of contract and contract terms that you wish to see, whether that be through a formal procurement process or just the manner in which you are approaching negotiating terms and conditions with another party. And once you've identified those, important from an organizational perspective to be mindful of what obligations you have agreed to and to ensure their continued review, implementation, and enforcement. We have about 10 minutes left in our session today, so before I move into a wrap-up on the session, I'm pleased to open it up for any questions from the group. I'm not seeing any questions that are being submitted through the chat box at this time, which means either I've been really clear or I've put you all to sleep. But certainly if you have questions that come up later, or there are questions that are more particular to your organization that you're not comfortable to ask within this group setting, you're welcome at any time to reach out and contact me with your questions. And my contact information is on the last slide. You can contact me directly, or for those of you who are engaged in our on-call program, can always send your inquiries through our on-call line. So thank you all very much for attending today's session. We would appreciate if you would take a couple of minutes to fill out a survey page that you will be provided. Your feedback is always welcome, both on this session as well as on future topics that you may be interested in. Today's Coffee Talk Health Industry Seminar was the last one of our 2018 season. We're currently finalizing our curriculum for 2019, and we look forward to connecting with you in the new year on a variety of new topics of interest. So please let us know what they are. Thank you all for attending, and have a wonderful day.